close to 2 decades now. And I recall famously was led by lawyer Chris Akume, and they've had many issues with the Ghana Bar Association. We'll come to that. But first, thank you very much for your time. Good morning to you.
Good morning.
And it's nice to have you on the line. I hope everything is well.
We thank God, and good morning once again to your cherished listeners.
First, let's start with, because I listened to my colleague go through the reliefs that are being sought by the CJ. You get the impression that she is not approaching this from the perspective of the chief, the former CJ. Let me be correct, the former CJ. She's not approaching this from the perspective of being removed as Chief Justice, but being removed as a judge of the Superior Court of Judicature. Is that the impression you also get from reading the wreath?
All right, thank you so much. We must understand that we're dealing with a constitutional provision or a constitutional procedure. Now, the removal of a Chief Justice should not just be read in isolation. You must as well pay attention to the appointment of a Justice of a Superior Court. Now, you do not have a specific provision that says that this is in respect of an appointment of a Chief Justice. For which reason, there's an entirely different procedure that allows for that. As a matter of fact, the Constitution provided for the appointment of justices of the Superior Court of Judicature. And this includes High Court Justice or Judge, Court of Appeal, and the Supreme Court. The only difference you might see has to do with whether the person will appear before Parliament or Appointments Committee of Parliament for purposes of vetting the person to ascertain the qualification or the otherwise of the particular appointee. And that's where either the President or the Judicial Council has a critical role to play. And so to that extent, when you are looking at an appointment in respect of a person appointed to the Superior Court of Judicature, and specifically in this case, the Supreme Court, it is the same procedure for all persons appointed to the Supreme Court. This means that you do not have a different procedure for somebody who is being appointed as a Chief Justice. And that's why the Constitution has provided for a situation where someone who is deemed to have met all the requirements or the qualifications in terms of ethical standards, moral standards, proven integrity, and the like, is appointed on the basis of those qualifications, either to a court of appeal, Supreme Court, or even High Court. So that minimum requirement is there. And so when they appoint me, it is this fundamental requirement that serves as the cornerstone on the basis of which a person may be appointed to Supreme Court in this case. You do not have different set of qualifications for somebody to be appointed directly from the bar to become a Chief Justice. You don't have a situation like that. However, a person can be appointed straight from the bar to the court of to the Supreme Court. And I give you a classical case of His Lordship Justice Yoni Kolende. And so to that extent, you can only say that for one to be appointed a CJ, first and foremost, it is on the basis of the fundamental requirements of you becoming a justice of a superior court, such as the Supreme Court, that you may as well be appointed as a Chief Justice. And so you will find it very difficult to now try to decouple the two, especially when you are a Chief Justice. When you are a Chief Justice, automatically, you are a Justice of the Supreme Court, and then additional responsibility for purposes of administrative flow of the work of the judiciary. In this case, the Constitution has provided that you become the arrowhead, being in charge of supervision and then administrative activities, because there must be someone to be assigning case, there must be someone to be empaneling. So those additional responsibilities, either in terms of administrative or supervisory, become the additional responsibilities of the CJ. And by recognition of those additional responsibilities, that is why your benefits may be relatively better or higher than your colleague justices of the Supreme Court. And so you cannot, by any stretch of imagination, think that if you were to commit an offense, for which reason you are no longer, just for purposes of the discussion, if you were to commit an offense, for which reason you are not qualified to become the CJ in this case, then it is reasonable to say that you are not qualified to be the CJ, but you are qualified to be what the Supreme Court justice. No, that's why I say that the requirements for whoever is becoming a Supreme Court judge is the same, because it is on the basis of that that the person becomes a Supreme Court judge, and subsequently may be lucky to be appointed as a Chief Justice. So it tells you that the foundation remains the same. And so I'm struggling to see how someone will try to, rationalize to make it look like someone can be appointed straight away as a Chief Justice without first and foremost being a Supreme Court judge. That rationalization will not work. And that the Constitution itself never anticipates such a thing. If it were to be this case, the Supreme Court or the Constitution itself would have been very clear on that. And there's no ambiguity in that provision whatsoever. So I don't know, but sometimes when we find ourselves in very, challenging times, we try to exploit every avenue that we think might aid us have our way. But I can assure you that, this is not something that the Constitution itself envisaged, and the framers never anticipated that there will be a situation where you can be appointed a Chief Justice, and then, of course, by reason of any qualification, you will be disqualified as a Chief Justice, but still remain as a Justice of the Superior Court, and for that matter, a Supreme Court judge. It doesn't operate that way. It is inherently attached to your qualification as a Supreme Court judge in the first place. And so the two is not mutually exclusive.
Is that the sense you get from reading it, that she's saying that there has to be this process that was followed can only remove her as Chief Justice? Is that the sense you get, that she's arguing that the process that was followed can only remove her as Chief Justice, but not as a Justice of the Superior Court?
And that's the point I'm making. You see, when you look at Article 140, it has about 11 clauses, 1 to 11. Now, when you take 1 to 5, it tells you what to do in the event that you want to remove a Justice of the Supreme Court, which means that when a petition is first initiated or instituted, you must forward the petition to the Chief Justice. In this case, you are petitioning the Chief Justice directly for purposes of removing a Justice of the Supreme Court or a Justice of the Superior Court of Judicature, which means that High Court, Court of Appeal, Supreme Court. Now you are simply petitioning the Chief Justice for removal of these other judges of the Superior Court because she is the administrative head. And I just mentioned that there must be leadership. So the petition is simply meant to be delivered to the CJ, who then will now go ahead on the basis of agitum and other related cases or authorities to now determine the prima facie case. You understand? On the basis of which probably the president then comes in when a committee has to be constituted. Now, it is not possible for petition to be forwarded or initiated for the removal of a Chief Justice, and you then expect that the same petition will come to you as the Chief Justice for your own removal. You cannot be a judge in your own cause. Natural justice. And that is why it must, in this instance, be forwarded to the president. And that's why I'm saying that there's a departure over there, because 1 to 5 will deal with a situation where you are removing a justice of a superior court other than a Chief Justice. That's where you petition the Chief Justice. Then she will initiate whatever has to be done. And then before the president also comes in and all that. But where it is for purposes of removal of the Chief Justice herself, who is also a Supreme Court judge. And I'm saying it's an amalgamated title. You are first and foremost a justice of the Supreme Court before even a CJ. And so you cannot decouple it, especially when you are now the CJ. You may try to decouple it when you are a Supreme Court judge and not a CJ. But as long as you become a CJ, the two become automatically fused together. Because whatever a Supreme Court judge can do, you can do it as well. But not every Supreme Court judge can do what the CJ can do. You can only do it when the law empowers you or the Constitution empowers you to do so.
I see.
And so, for purposes of removing the CJ, the Chief Justice, the petition will not come to you again, because if it should come to you, then it will as well mean that you should go ahead and determine a prima facie case against yourself. And nobody will do that. It will take only sincere and honest people to do that. The framers anticipated that there must be fairness, and there must be transparency, there must be accountability, there must be sincerity even in the exercise of our functions, either judicial functions or judicial authority. So it will not come to her. So she wants it to be treated as though it should have come to her. Therefore, she should be the one to determine a prima facie case. It doesn't operate that way. The Constitution is clear about that. That if it is you, the matter relates to you. You might have harmed other people, of course, in the performance of your functions. You might have as well abused your office. You must have exceeded your authority. You might have undermined certain people in the performance of your functions as a CG or even as a judge of the Supreme Court. You are not an alpha and omega. There must be checks and balances. The ordinary people should be able to check you by way of petition. They should bring the petition to you. It doesn't work like that. It must go to the president, who will now engage the Council of State, constituted by persons of independent mind, persons of a certain repute in society, persons who command the respect of the society, persons who are deemed to know the law as well, who are deemed to appreciate the concerns of the ordinary people as well. Then they will now look into the merits of the petition and determine whether indeed there's a case made out for you to answer. That is the procedure. And I'm saying that you cannot interpret it to mean that it is a procedure instituted for the removal of a Chief Justice, but not you as a Supreme Court judge. In your case, it is an amalgamated case which cannot be decoupled. If it was intended to be decoupled, the Constitution would have expressly stated so. And so that is what needs to be done. That is why when you are looking at Article 146, 1 to 5 dealing with the procedure for removing a Superior Court Justice aside the Chief Justice, then 146 now tells you that in the case of the Chief Justice, it is the President who must receive the petition. Then continue his actions from there in terms of whether there's a need to determine a prima facie case has been determined or made out or not. And if it has been made out, the next steps will proceed from 146 clause 7, 8, 9, 10, 11. And that is why, if it is for the Superior Court of Judicature in this case, whether CJ or the Supreme Court judge, there's a room for suspension. The person can be suspended.
Okay.
And that suspension applies to both, whether it is you, the CJ, or the Superior Court judge. And that suspension is part of the procedure.
Okay.
So it is not the case that if it were a CJ, there's no suspension made for you. But if it is a Supreme Court judge, suspension has been made. And I'm saying that in both cases, there's still a suspension. So the Constitution is simply saying that as far as you are concerned as a CJ, whatever is supposed to happen to a Supreme Court judge will apply to you, except that in your case, because you have that additional responsibility, they will want to treat you to reflect your position in that sense by just creating a certain departure, which is to give recognition to that role you play, and not necessarily to say that you are not supposed to follow that procedure. It's just to give you the recognition. And the recognition here, let's do it once again, is to say that when anybody intends you to be removed, the petition must go to the president and not you. But if it comes to you and you have to determine whether or not the prima facie case has been made, who will do that? How many people will do that? Especially when you have become so obsessed with your position or your office. You wouldn't be sincerely enough to say a case has been made against you, and therefore they should proceed and constitute a committee to look into your matter. And again, even the composition of the committee, who knows? You might want to even be the one who have an influence as to who should be members of the committee. And so that argument is completely out of order.
Okay.
It's not a proper and a true understanding or application of the law if you look at the provision very critically.
Well, we would have to leave it here. And thank you very much for that clarification. Okay, so some education coming from lawyer Sadat Haruna Al-Hassan. And in fact, if you go to Article 146, the heading is removal of justices of superior courts and chairman of regional tribunals. They don't even mention chief justice in there. Removal of justices of superior courts and chairman of regional tribunal. And you go through Article 146. You hear the first provision, second provision, third provision. So clause 4, clause 5. The committee appointed. Then where it comes to 6, it says where the petition is for the removal of the chief justice, the president shall acting in consultation. Because if you look at the earlier ones, we start a justice of the superior court or a chairman of the regional tribunal shall not be removed from office except for stated misbehavior or incompetence on ground of inability to perform the functions of his office arising from infirmity of body or mind. And it says a justice of the superior court of judicature or the chairman of a regional tribunal may only be removed in accordance with the procedure specified in this article. It says if the president receives a petition for the removal of a justice of a superior court other than the chief justice. Remember, if the president receives a petition for the removal of the justice of the superior court other than the chief justice or for a removal of the chairman of a regional tribunal, he shall refer the petition to the chief justice. To the chief justice, who shall determine whether there is a prima facie case. I do not know, because the suggestion from what Nancy read is that she feels that, okay, now you have removed me as chief justice, now remove me as justice of the Supreme Court, which is quite weird. Because like I said, if you read the heading, the general heading is removal of justices of superior courts and chairman of regional tribunals. Removal of justices of superior courts and chairman of regional tribunals. It's all very, very, it's clear, very, very clear there. It's just when you get to Article 146.6, where it says where the petition is for the removal of the chief justice, because in the case of any other judge, the chief justice takes the lead. So if the chief justice is the one who makes the prima facie determination in the case of any other judge, where you turn to the removal of a chief justice, the president cannot send the petition back to the chief justice. You cannot be a judge in your own case. I think that's a basic rule of what they call it, how the law works. Just a basic rule. It's common sense. You cannot be a judge in your own matter. So they give it to somebody else to handle. And you are only chief justice because you are a judge. I've never seen a president come and say, Colonel Kojokuma, come and be chief justice. It doesn't happen. It doesn't happen. In fact, they cannot even call a judge at the circuit court to be chief justice. No. So you cannot just call just anybody. Oh, Nancy, you know some small law. Come and sit there and be chief justice. No. You have to be a judge first of a particular caliber before you become the chief justice. So you're a chief justice by virtue. So it's like we remove the IGP from position. IGP says, now you have removed me as IGP. I want to still be a police officer. What are you talking about? So is the argument that is being made. It's quite interesting because when you listen to what Nancy read, she's saying when you follow, yes, you followed it. It's good for removal of chief justice, but not the procedure for the removal of a justice of a superior court of judicature. And that's what I get from listening to Nancy. It's quite clear for me that is the argument she's making. It looks like she's not going on the tangent of saying that they removed me wrongly as chief justice and I want to be reinstated as chief justice. I think she's saying that the constitutional provision is separate for two things. So for her, when she was Chief Justice. Now that she's been removed as Chief Justice, she can go and wear the wig and say, former CJ, you are here. So I don't know how the whole thing is so